Welcome to Notable Approvals. I'm attorney Amanda Shaffer. Today we have a great case to talk about. Before I get to that, quick reminder, make sure that you like us and follow us on Facebook and Instagram and YouTube and wherever you get your news from us. Lots of good information on there. And if you find this video helpful or you know somebody who will, please make sure to share it with other people. So I was stalling a little to give some people a little bit more time to join than normal, just because I rarely do these notable approval lives before noon, but I have a friend's wedding to go to this weekend, so I have to get out of here soon so that I can travel to New Jersey later today for the wedding. So, and I really wanted to talk about this case because there's a lot of interesting things here, and it's also one where hopefully sooner rather than later, but in the near future, I will be doing an updated video on what happens next. So this is a client who is a native and citizen of Jamaica. He first entered the U.S. in April of 2013 on a O2 visitor visa. Those of you unfamiliar, an O2 visa is for O1 support personnel. O1s are your extraordinary ability visas. So there's support personnel for athletes. There can be for media, for artists, actors, like a lot of different O1 categories. You can have support personnel, and this client had initially entered using the O2 visa. And you are allowed to adjust status to a permanent resident from an O2 visa, just as if you had entered with a B1 or a B2 visa, or another popular one, of course, the F1 student visa. So this client, he had married a naturalized U.S. citizen, also from Jamaica, she naturalized in 2014, they married in 2017. Now, before that, both of them had been married previously. She had originally gotten her naturalization through family members. And the client's previous wife did file for him and it got denied. And he didn't really have a lot of paperwork when he came to us. So he came to us after his second wife, who's his current wife, applied for him, and that got denied. So she applied for the marriage petition and the adjustment of status application. Unfortunately, I went back to take a look at all the exact reason for the I130 being denied or the marriage petition. The client never had that and never was able to obtain it. And in his case, we ended up finding, I think we did a FOIA or started to do a FOIA, but then that's the Freedom of Information Act request where you can get your entire immigration file. But then he got placed into removal proceedings. So just to give you a better idea of the timeline, the I-130 and I-145 filed by his current wife initially was filed back in 2018, shortly after they got married. Then he had a previous attorney at this time. They appeared for an interview. It was a little confusing with the interview notices, actually, because they were canceled or rescheduled, but essentially they went to the interview, and I think they went to the interview or they missed the interview. That actually wasn't clear to me, but it didn't really matter, or I'm sure the client told me back then and I can't remember anymore, but it was denied. The I-130 was denied. Honestly, it was either a no-show at the interview or they just didn't believe they had a real marriage. And that was something we needed to know, of course. But what was strange about what the previous attorney did was when the I-130 was denied, he didn't appeal the I-130 or didn't file a motion to reopen or consider the I-130. But the I-485, which was denied the same day, he filed a motion to reopen because you can't appeal. It's a motion to reopen / reconsider. It's the Form I-290B, same form as if you are appealing. And the reason that the attorney had listed, according to the denial of the motion to reopen, was that they had gotten a couple different interview notices. Some were canceled, it was canceled or rescheduled. I don't, honestly, that's not even that important. What's important here to note is that if you're filing what's called a one-step adjustment of status, so you have your immediate relative is filing for you, so generally speaking, your U.S. citizen spouse, your parent, your child over 21 filing for your parent. What's the other? I always forgot one. Oh, and a parent must be 21. Filing fees must be 21 years or older. Yeah. Oh, I think I have that one twice. That was my little cheat sheet. Anyways, so point is that if you get a denial of your Form I-485, you can't file your Form I-485, which is the application for your green card, unless you have an underlying petition. So there's a couple different forms that could be the underlying petition. In general, you're going to have your I-130 petition for alien relative, or your I-140 petition for alien worker. If the I-130 or the I-485 gets denied at any point, whether you filed you filed everything together or you filed your I-485 after, if the I-130 gets denied, the I-485 is immediately denied. If you want to appeal the denial of the I-485 or ask them to reconsider or reopen it, you cannot do that unless you also ask them to do that with the I-130. Generally speaking, when the rare times that we find it advisable for a client to file the motion to reopen it or appeal it instead of just refiling everything, is when there was really a mistake made, but we only file the I-130 appeal because if that doesn't, what's the point of paying 2 filing fees if that doesn't get reversed, the decision, your I-485 can't be reopened. And if it does get reversed, you actually don't have to appeal the denial of the I-485 too. You can request that it be reopened, and actually USCIS is supposed to automatically do it. But you can also send them a request now to reopen because it was, and we've done that before, and we've reopened the case. So client comes to us, and he tells us, this history, and we're a little confused because, like I said, nothing seemed to really go the way it was supposed to go. So then what we did, said, all right, we don't really know what's going on here, but it seems like we're going to have to refile everything, but we're not sure if there's a fraud finding for this marriage or the previous marriage. And we talked about filing an I601 Waiver of Inadmissibility for fraud or misrepresentation. That's not going to work with marriage fraud, unfortunately, but it depends. It's a lot harder with marriage fraud, if that was the case. So we said, look, if we're not sure when we're filing it, and we don't, at this point, he had nothing to indicate there was any fraud, we're like, we hold off filing the I601, the waiver application, until USCIS says that you need to. Because as far as I can see here, all I know is it was denied. I don't know why. And if you didn't show up for your interview, then there's a chance that it was just denied for not showing up, and they don't talk about any fraud. Today is actually the Jewish holiday of Yom Kippur, and I do have an announcement on our website that we are not working today. I am in the office for a little while longer, as I said, but I did put up an announcement. The office is actually closed today, so we are getting phone calls just so I can catch up on some things instead of actually taking a full day off. Anyways, so back to, sorry, because the phone keeps ringing, I keep getting distracted. But back to the case at hand. So basically, so he comes to us and we're like, all right, well, we're gonna have to refile everything. So we start preparing the I-130, the I-485, a new work permit, a new travel document, etc. And this was actually during the very annoying time period where we had that Form I-944, the Declaration of Self-Sufficiency that Trump put in place and then Biden immediately removed. So, but he would have been one of those clients that was in the time period that we had to file it with him. As I'm waiting for all the signed documents and the evidence from the client, he gets placed, like I said, the I-290B eventually was denied, which was the motion to reopen. and he was eventually placed into removal proceedings. And that was last year. It was after the courts in New York has closed. He's in Philly. They were closed for they were closed when it first happened. So we then had to call him and say, hey, okay, well, we got to change our game plan. We can't file everything together now. The good news is when he came to us, this was before Biden was president, we said, well, the good news is it's probably better that this is in front of a judge instead of USCIS again. We don't want it to get denied and just be back here and make things take even longer. Trying to find the silver lining. Of course, Biden became president, things changed. That was great, but we filed the I-130 back in January of this year. And 7 months later, in February, less than 7 months later, the I-130 was approved without an interview. So what did we do differently than the first time? As I said, I never saw the old application. I didn't have to necessarily, I like to see what clients have filed. I always request it. If there's a pressing issue to order the FOIA file, we certainly do before we do anything. In this case, we didn't think it was going to make a huge difference. We were trying not to take too long to wait before we filed everything. So I hadn't seen it, but once you're placed into removal proceedings, if you then are filing a marriage petition, you're going to have that higher burden of proof. And that's what I was worried about, because either they didn't show up, which isn't good. It's not better than you showing up and bombing the interview. It's maybe slightly better in that they don't have a specific fraud finding to point to. However, it is an indicator of fraud. So that gets confusing. I don't know all the paper documents he submitted the first time around. What I do know is what we submitted when he came to us. So we did as much, of course, as we possibly can. They do have a son together. So we filed his birth certificate, best evidence you can have. They had joint taxes. They had 2 joint checking accounts from different time periods. One was closed for overdrafting or something, but they did open another one, which was a really good thing. Joint electricity bills, and then lots of wedding photographs and photographs with family and friends and their son. And I think we even have photos from the hospital, which is very nice to have. So I was expecting an interview because he's in removal proceedings. And of course, along with all that stuff, their marriage certificate, we put in the judgment of the divorce and the notice of order, the notice to appear in removal proceedings. So needless to say, when I got this approval notice the other day, I was surprised because they didn't have an interview, which I thought you were actually required under the Immigration and Nationality Act. I know if you get married after you're placed in removal proceedings, but and Philadelphia is slightly different than New York, I think, with their Stokes, but very similar. I thought if you're in removal proceedings, file a marriage petition, Stokes interview off the bat. That's where you get separated. You and your spouse get separated. You get questioned separately, brought back together to go over every discrepancies, and then decisions made. And it's usually the second interview if you're not in removal proceedings and didn't have a previous issue with fraud or anything. So when I got the interview notice, which I have in front of me, I was a little confused when it said that the above petition has been approved. As the petitioner requests, we've sent the petition to the National Visa Center to do consular processing. Client cannot do consular processing. He's in removal proceedings. And he's eligible to adjust in the U.S. because he has an entry with inspection and admission, meets all the other requirements. So, and so I went before I have to talk to the client anyway about our next steps. If he may be watching, he might not be, but I'll call him either way. When I went back and looked at the form, I'm like, there is a part on the I-130 form that asks, will the beneficiary be adjusting status in the U.S. to get the green card or leaving to do consular processing and entering with an immigrant visa? And we wrote in Philadelphia, PA. And then the next part where if you're going to do consular processing, I wrote N/A, not applicable, N/A. So I don't know why they sent it to the Department of State. What I can tell you is that I don't think we've had this happen before. It's rare. It's worse if it's the other way around. If you're supposed to do consular processing and for some reason it gets filed as a as an adjustment of status, then you have to file another form to transfer it abroad because it has to get transferred to the National Visa Center. In this case, it's been a while since they made this mistake, especially someone in removal proceedings. I'm going to have to like just double, triple check on this, but I'm like 98% sure that it shouldn't make a difference in this case. I might end up, no matter what, sending like a letter to National Visa Center letting them know that this was a mistake. Hi, Ricardo. Thanks for watching. And thank you for the compliment. He wrote that, the best lawyer. Okay, so basically, this is awesome that it was approved either way. Made life a lot easier, not having time to worry about an interview. So the next step we have to decide is, now that prosecutorial discretion is back, are we going to request to terminate his proceedings or just go in October, get an individual hearing, do it before the immigration judge? Or I found another reason to request it to terminate, not just because the I-130 was approved, but after he was placed in removal proceedings, there was I think it was between this year and last year, he, on the notice to appear, it said at a time to be set and a date to be set. And there was a court case that came out after this that ruled that that's an invalid notice. So basically his proceedings should be terminated because they gave him an invalid notice. So we can file on multiple grounds, but we're going to talk about all of that and decide what's the best. Because like I said, some of these details, when I wanted to confirm before I did the video, and I just didn't have some of the paperwork because I don't think we ever had the paperwork, or it could have been stuff I saw once and gave back because I didn't need it anymore. But basically, I just want to double check a few things with the client, make sure that there wasn't any other issues I'm forgetting about, and that there isn't a fraud finding I'm forgetting about, so that it makes sense to actually terminate proceedings. Because you don't want to terminate proceedings, go to your green card interview with USCIS, and then end up back in removal proceedings after a denial. So whatever we do, we have to file a new Form I485. It's the green card application. We're going to ask Department of Homeland Security, most likely, to join a motion to terminate. It will get terminated. We do it with USCIS. That is most likely going to be a plan, but again, I will do an update video in the future once all this stuff gets sorted out. Hopefully it won't take too long. But we're very excited for the client that this was approved and that we can move on to the next stage of his case. So that was a long-winded one. I thought I was going to take like 5 minutes to explain this. It took a lot longer. Like I said, there was a lot of it packed into this, and I did want to make sure that I kind of covered it all because it's a very interesting case, especially when you consider the fact that this wife filed for him previously denied, and then wasn't too long ago, and that we were able to get it approved without the interview. So that's a really good thing. So check back. I'll put some type of link to let people know I'm updating a case in the future. So keep your eye out for that. Otherwise, I will be back ASAP with another notable approval, and got some more live videos coming up as well. Our game show, if you missed the last Are You Smarter Than Naturalized Citizen, we had a hurricane interrupt our episode. So we're still trying to replan that one, or we might finish that one up later on and go to episode, I think we're on 14 now. So check back on our page as well for the announcement on that. If you like us or follow us on Facebook or YouTube or Instagram. Instagram doesn't give these notifications, the other two do, but I do post it. I post all the events, so you can still, if you follow us, you should be able to see it. Hopefully you'll join us for that and catch some of our notable approvals. I have a bunch that I haven't been able to do yet, so I hope to get to a couple, well, at least one next week. So as I said, that's all today. Thank you for watching. Don't forget to like, share us, follow us on the social medias, and we're available for hire, of course. Contact information. If you're on YouTube or Facebook, has been scrolling across the bottom of your screen, and Instagram, go to our profile page, and it should be all there as well. All right. Have if you're fasting, I hope you have a good break fast and a sweet new year.